Welcome to lecture number 2, the reasonable expectation of privacy test. The scope of the modern-day right of privacy often focuses on whether a person has a reasonable expectation of privacy. As we will see, this concept permeates all privacy laws, whether based on common law, statutory law, or the Constitution. The test was first articulated in the 1967 U.S. Supreme Court decision in Katz v. United States. Justice Harlan, in a concurring opinion, formulated the test in the context of the Fourth Amendment's right against unreasonable searches by the government. In Katz, FBI agents had attached an electronic listening device to a public telephone booth and recorded the conversation of a person transmitting wagering information in violation of federal law. The conversation was admitted into evidence, and the defendant was convicted. On appeal, the Court of Appeals affirmed the conviction and rejected defendant's argument that the recording was obtained in violation of the Fourth Amendment, holding that a public telephone booth is not a constitutionally protected area and there had been no physical invasion of the telephone booth by federal agents. The Supreme Court rejected the Circuit Court's analysis and formulated a new test for deciding whether the Fourth Amendment was applicable in a given situation, the so-called reasonable expectation of privacy test. Two circumstances must exist to satisfy this test. First, a person must exhibit an actual, that is, a subjective, expectation of privacy. In other words, the person must have taken some action to ensure his privacy. And second, the expectation must be one that society is prepared to recognize as reasonable. This provides some elasticity to the test to reflect evolving concepts of privacy. For example, when cameras were large, expensive, and owned only by a few, it was reasonable to expect that one would not be photographed, even in a public place, without consent. Today, however, with the pervasiveness of camera-equipped smartphones, such an expectation is not likely reasonable, absent some other exigent circumstance. Applying this test to the facts in Katz, Justice Harlan concluded that one who occupies a phone booth and, quote, shuts the door behind him and pays the toll to permit him to place a call is reasonably entitled to assume that his call is not being intercepted, end of quote. Thus, determining whether a right of privacy is implicated is often contextually based. This context may include, for example, where the person is located when the claimed violation of privacy occurred. For example, one reasonably has a greater expectation of privacy in one's home than in a public space. The nature of the information or interest involved is also often a context in applying the reasonable expectation of privacy test. For example, there is a greater expectation of privacy in one's personal, medical, or financial information than in information generally known by the public or freely shared with others. And finally, the manner in which the alleged invasion of privacy occurs. For example, via wiretap, by breaking into a private space, by employing sophisticated technology, or by using deceit to gain access or consent. All are contextual circumstances that affect the reasonableness. The contextually based Katz test underlies the common law privacy torts, many of the statutory privacy protections which have been enacted over the years, and informs the application of the protections under the Fourth Amendment. Throughout this semester, keep the Katz test in mind as we discuss the various cases and circumstances where the right of privacy is recognized or rejected. The Katz test has stood the test of time, but commentators and courts are beginning to question its continued viability in light of technological change. In Lecture 3, we will review the 4 common law invasion of privacy torts.